My name is David Petrosky. I'm an eviction attorney representing landlords in California on eviction cases. Today I'm going to be discussing the landlord's right to enter the rental unit in California. This is a question that I receive frequently when landlords want to enter the property for a certain reason, and they ask me when and under what circumstances they have the right to enter the rental unit. This video will answer those questions. First, I'd like to tell you briefly about myself. I've been handling eviction cases for landlords since 2004. I'm a 5-star law firm, and I'm a published author. I am a great referral source for many real estate agents, landlords, and other attorneys, and we get results when we have to file eviction cases against tenants. Of course, there's no guarantee of success on any one case. Okay, let's dive right in. The landlord's right to enter a rental unit in California is outlined and codified in California Civil Code 1954. That is sometimes referred to as CC 1954. Civil Code 1954 outlines when and under what circumstances a landlord can enter the rental unit when a tenant is in possession. So what exactly does Civil Code 1954 say? Here are some highlights of Civil Code 1954. A landlord may enter the rental unit only in the following circumstances. So remember, if you're a landlord, you have to fit your reason for entry into one of these specific enumerated categories. Number 1, in the case of an emergency. Number 2, to make necessary or agreed repairs or to exhibit the dwelling to prospective purchasers, mortgagees, new tenants, workers, or contractors, to make a necessary inspection, to make alterations or improvements. It's all outlined right here in Civil Code 1954. You can also enter when the tenant has abandoned or surrendered the premises, but that can be tricky and you're going to want to consult with legal counsel. Finally, a landlord can also enter a rental unit pursuant to a court order. Now let's discuss some of the specifics on how a landlord can enter. Well, except in the case of an emergency, a landlord may enter the rental unit only during normal business hours unless the tenant consents otherwise. If you have a really good lease, the lease will specify what's considered normal business hours. But if your lease is silent on that issue, then you would want to utilize what's considered reasonable normal business hours. Also, and again, except in the case of an emergency, the landlord must give reasonable notice in writing to the tenant that the landlord intends to enter the unit. The written notice should include the date, approximate time, and purpose of the entry. And remember, the purpose of the entry must fit into one of the categories on the previous slide. The written notice can be given to the tenant personally. It can be left with someone of a suitable age and discretion at the premises, or what happens a lot of times is that the landlord can place a copy of the written notice at the front door of the rental property, and to do this, the landlord can tape a copy to the front door. Normally, if the landlord does this and tapes a copy of the notice to the front door, 24-hour notice is generally an accepted length of time for reasonable notice. If the landlord wants to mail the notice to the tenant, then reasonable notice is considered 6 days for mailing time. So you would mail the notice to the tenant at least 6 days before the landlord intends to enter the unit for an allowable reason. Please take note that the law does not specifically allow a landlord to give email or text message notice. Different rules apply if the landlord is going to exhibit the property to a prospective or actual purchaser of the property. In addition, the landlord and tenant can agree orally to an entry at any time. And in the event of an emergency, the landlord can enter the rental unit at any time. So for example, if there's a water leak or a gas leak or another emergency, the landlord doesn't have to give the 24-hour notice. They can enter the property at any time in the event of an emergency. If you'd like additional information, I encourage you to do a few things. Number one, be sure to follow us on Facebook. I publish a lot of articles on Facebook in addition to posting a lot of relevant news articles on landlord tenants and the relationship in California. On my website, which is attorneydavid.com, you can fill out a contact form to get a free consultation if you're a landlord in our service area. On the website, I also offer many free forms for landlords to download. If you want more information on Civil Code 1954, you'll see a link here on the screen to the blog article that I publish. It goes into more details on the landlord's right to enter the rental unit. Also visit our blog regularly, which is attorneydavid.com/blog. Follow us on YouTube. I do publish videos that discuss landlord-tenant relationship. You may find those useful. If you have any questions, feel free to reach out to us. The website is attorneydavid.com. Thank you very much.